The petitioner was tried before a jury on charges of murder in the second degree, criminal possession of a weapon in the second degree, and criminal possession of a weapon in the third degree under Kings County Indictment number 987092. After presentation of the evidence was completed and the jury was charged, in commencing deliberation on April 25, 2001, the jury was sequestered for deliberations. On April 26, 2001, while returning from dinner, juror number 2 suffered an apparent seizure and was taken to the Long Island College Hospital emergency room. The next morning, Friday, April 27, 2001, the Supreme Court related to the parties that it had spoken by telephone with the doctor for juror number 2 and had been told that the juror was a very sick man who has had a heart problem since 1999 and that problems had been discovered with his liver. The doctor did not, as of the time of her phone call to the court, have the results of the various medical tests performed on juror number 2. Therefore, the doctor could not make a firm decision about juror number 2's condition until the following Monday, which would be the earliest date he would be released. The doctor informed the court that regardless of what the test results revealed, she would recommend from 1 to 2 weeks bed rest for juror number 2 after his release from the hospital, and that even if he could return to work, she did not think under these circumstances that he should become involved in the stressful situation of jury deliberations. The petitioner then requested an evidentiary hearing on the issue of medical necessity before determining whether a reasonable alternative existed which would permit continued deliberations. The Supreme Court denied this request and extended to the petitioner as an alternative to a mistrial the choice of agreeing to a non-sequestered jury that could stand by until juror number 2 was well enough to continue deliberations. The petitioners rejected the offer. The Supreme Court concluded that it could be unreasonable to keep the jury sequestered and declared a mistrial. The petitioner commenced the instant CPLR Article 78 proceeding prohibiting the retrial under Kings County Indictment number 807092. Generally, double jeopardy will bar retrial when a mistrial is granted over the defendant's objection, or without his or her consent, unless the mistrial is granted as the product of manifest necessity. Matter of Davis versus Brown, 87 New York 2nd, 626. In determining whether such manifest necessity exists, there must be a high degree of necessity before concluding that a mistrial is appropriate, i.e. the reasons underlying the grant of a rule of a mistrial must be necessitous, actual, and substantial. We reject the petitioner's contention that the Supreme Court erred in declaring a mistrial which was conditioning an evidentiary hearing to establish the facts necessary to a determination of manifest necessity. The doctor made it clear that the test results would not change her recommendation that juror number 2 have from 1 to 2 weeks bed rest upon discharge, and thus the juror would not be available to continue deliberations for at least 9 days. As a result, no hearing was required, as no new information not already available to the court would be revealed. Under the circumstances, the termination to grant a mistrial was proper. The remedy of prohibition is available only when there is a clear legal right to the relief sought, and then only when a court in cases when judicial authority is challenged, acts or threatens to act either without jurisdiction or in excess of its authorized powers. That's it. You good?
It's okay. Yeah, I think I got it.
You know.